I will serve as trustee as long as I'm alive, as long as I don't resign, and as long as I'm not disabled as determined by the disability panel. Who do you put on the disability panel? Children, good choice. The people that you would choose to be trustees and executives, put them on the panel. Or you can put the beneficiaries on the panel, and sometimes that's all the same thing. For me personally, I have 5 children. I'm married. 6 people are on my panel. So those 6 people make the decision at some point when I am no longer able to function as a trustee, and they can
didn't get all of that.
literally within 24 hours. That's a good thing, by the way. That's not a bad thing.
No, it's a good thing, and it's very safe, because the moment you are removed as a trustee, all of these protections that are written into the document kick in, and everything has to be held in trust for your benefit. So, in other words, there is no incentive to remove somebody prematurely. In fact, you know, when we are starting to talk to trustees and things about is a client becoming incapacitated, we have that discussion with them, because that's when all the work starts, is if you get removed as trustee, but it sometimes needs to happen for the protection of the trust maker.
Now, let's couple this with what Jennifer just said. If you are a sole trustee and we remove you as a trustee, we don't have a trustee for 30 to 45 days. If you have a co-trustee and we remove you, that person takes over immediately, just like the co-pilot does.
Yeah, really good system. And so the question now is, well, where does the financial power of attorney fit into all this? Because we've talked about a silent partner trustee provision for temporary incapacity. We've talked about removing you as a trustee if you become permanently incapacitated. And that's the disability panel. So what purpose is the financial power of attorney? Do we even need one? The answer is yes, we do. And it has a very important purpose, and that purpose is to handle everything that happens outside of the trust. So if you have an IRA, a 401k, if you have an insurance policy, you have a credit card, you have vehicles, you have other stuff. I mean, the list goes on and on. There will always be stuff that's not part of your trust. Always. If you lose the ability to sign, those assets are not going to be covered by your trustee. So even if we have a silent partner trustee and a disability panel, they still need authority over all this other stuff. And that's the financial power of attorney. What we've discovered, though, is oftentimes the financial power of attorney doesn't work when it's needed. And there's 2 major reasons why it doesn't work. The first is it's usually too generic and too short, meaning it just says, here's my power of attorney, I give my son power to sign my name, and he can do whatever he wants. I'm paraphrasing it, but it's literally that short, like 1 page.
It's pretty close.
And so he goes to use it, your son does, your power of attorney, and the financial institution says, you don't have authority to do what you're doing. Well, yeah, I do. I have authority to do everything. Where does it say everything? Everything is not everything. It has to be listed out specifically and explain what things he can and what things he cannot do.
Because they're worried about their liability.
The bank
keep
is
that in mind.
always worried
If
about
it's
their
too
liability.
generic,
Yeah.
it's like, oof, I don't know if we should interpret everything to mean that you can literally do everything. And also, you don't want your power of attorney agent to literally be able to do everything. For example, you don't want them to be able to change your beneficiaries in your trust.
Right.
By the way, that is not an extreme example. The powers of attorney that we see all the time gives the agent the power to amend and modify the beneficiary in the trust. And so if you look at that and you say, well, they never intended that, well, okay, what else in here didn't they intend it? It has to be very, very specific.
Yeah. So that's number 1. You want to have a power of attorney that is very specific on what they can and can't do. The second one, and this is incredibly common, I would say 75% of the powers of attorney
Easily.
we look at have this restriction, and the restriction is what's called a springing restriction. Springing means you give somebody authority to sign your name, but only if you're incapacitated. And then when it's been proven, and that's the hard part, that you're incapacitated, then it springs into existence. So somebody goes to use your power of attorney, and they find out that there's this springing part, and they go, well, what does that mean? And the bank or the financial institution says, well, you need to go get 2 doctors to certify it. Now here's the tricky part. We've talked about how difficult it is to get doctors to sign off. It gets worse with the power of attorney. Power of attorney dies with you. You can't use a power of attorney after someone's passed. And so oftentimes powers of attorney are needed in emergencies. Something's going on, someone's health is failing, it's not good, and so we're racing to get something done before the power of attorney is useless. And as soon as they put that 2-doctor stumbling block in the way, it can often trigger even bigger problems. We had one just recently, I'll just share this real quick, where a gentleman, he wasn't a client of ours, but his daughter came to us for help. His house was not in the trust. He had refinanced over the years, and they'd taken the house out of the trust. And
Very common.
very common. And in the end, it was in his name alone, not in his trust, and he was passing away. His health was failing. The problem is he had dementia, so he couldn't sign a deed to put it back in, so we turned to the power of attorney. The power of attorney said, you need 2 doctors to sign this. I told the daughter, you get 2 doctors, it's going to be tough, but you got to do what you got to do. She got 1, and then her dad died. She never got the second doctor to sign off. Now he is going through probate. Or he's not, his daughter is, but his house is going through probate, which, really sad. He had a trust. He thought he did everything right, but because he had this springing power of attorney, it messed everything up.
And that was the question that was brought up is, how is it possible that it's going through probate when there is a trust? Classic example of the asset not being in the trust at the time when it was needed, and the power of attorney not being a very good backup tool because of this serious restriction. Now, sometimes you will see springing power of attorney right up the top. You've seen it, you don't know what it means, you ignore it. A lot of times it's buried in the fine print that says it's springing. It's not just so obvious.
And it doesn't even say springing sometimes. It's not called springing. It
Right.
says, you could sign my name after I become incapacitated.
Yeah,
So, anyway.
very sneaky. There's another issue if you become incapacitated permanently or temporarily and you're not able to make medical decisions for yourself. And this is where the Advanced Healthcare Directive comes into play and the HIPAA authorization, which by the way should be 2 separate documents. A lot of attorneys combine them into one document. They put the HIPAA authorization language into the healthcare directive, which violates the law and invalidates the HIPAA authorization. So 2 separate documents are needed. I'm going to be really clear that we don't necessarily have magic language that should be in either one of these documents. They're very standard for good reason. If there's an emergency and you've got doctors and nurses and emergency staff interpreting an advanced healthcare directive, we don't want to have it chock full of fancy legal jargon. That's in the financial documents that are interpreted by banks and judges and attorneys, etc. This needs to be something that's a little bit more standard. Here's the issue with these documents. You've signed them, you have them in your estate planning binder, and where is that binder? It's at home on the bookshelf, or it's in a safe deposit box at the bank, or the point is it's not with you when you leave the house. We're estate planning attorneys, and I'm not walking around every time I leave the house with my huge binder of documents.
But you're tempted to, right? You love it so much.
I love it so much, but I am not tempted to lug around this huge binder. Oh my gosh. So it's obviously not with you. Now you leave the house and you have a heart attack, or you're in a car accident, or you trip and fall, or have a stroke, and you end up in an emergency room where you didn't intend to be, and you can't answer questions. Or this happened to me just recently. I was at home. I ate dinner with my family, and I have never had an allergic reaction like this in my life. But whatever I ate triggered an allergic reaction, and I got hives all over, and my face swelled up, and then my throat started to swell, and I started having trouble breathing. So we hopped in the car, and
you said, wait, don't forget the binder.
Right.
Get my estate plan.
I couldn't breathe. We were panicked, so I was taken to the emergency room, and they were afraid that I was going to lose consciousness. And I was afraid too, quite frankly, and of course I didn't take my documents with me, so that's pretty scary. Luckily, I had the solution in my wallet. It's called an emergency medical information card that we prepare for all of our clients. And this card links to my Advanced Healthcare Directive and my HIPAA authorization so that the doctors know who they can speak to if I do lose consciousness, and whether I want life support and who gets to make decisions for me. So I have this card in my wallet. I also have a little sticker on my driver's license in case I'm taken in and I am unconscious. It says, look for my emergency medical card, and that's located right behind the license. But I was conscious, thankfully. I pulled my card out and I handed it to them. I can barely breathe, so I didn't have to say a word. I handed them the card, then they look at it because they've never seen it before, but it has explicit instructions right there, and they whisked it away to their computer, and they were able to pull up my Advanced Healthcare Directive, and then they brought the card back to me and put it back in my wallet and just sat there and waited for, the epinephrine shot to kick in. And I was okay, and so I can laugh about it now, but in all seriousness, this card has been a almost literal lifesaver for many of our clients. And your spouse can have a photo of the card, your kids can keep a photo of the card on their phone. So it's just brilliant. Everybody should have it. Now I speak from experience. Anything can happen, and having this card can really be a lifesaver.
So the question is, I'm recapping, the question is, if you have this important document and it's drafted correctly, but you don't have it when you need it, what is the point of having it? And my question to clients is, what was the attorney thinking when they drafted this emergency document with no access to retrieve it in the emergency? It doesn't make sense.
Right, it really doesn't. So that was did you want to? Oh, okay, you took a breath, so I wasn't sure if you wanted to ask. Oh, that's good. I like that.
After your talk,
right.
he was nervous about his respiratory system.
Okay, good. No allergic reactions for you. So this is good. So, these are some of the issues that we see for incapacity, and they're really critical to address. Well, we want to shift gears now to something totally unrelated, but just as important for different reasons. And this is called the capital gains tax trap, because it really is a trap that can be buried in your documents, and it is virtually impossible to find if it's there.
So let's get into the details on this capital gains tax trap. And we're going to get into some specific examples of this. In fact, I'm going to tell you a very detailed story that just recently happened, and it's happened multiple times in the past, but this was the most recent one, about how this tax trap can really trigger some havoc for your family. I met with a couple of siblings a few weeks ago. Their parents had both passed away. Mom had died many years ago, and then Dad had just recently passed away. And they had this home they had inherited. It was their family home. And they said, we want to sell it because neither one of us live local and we don't want to rent it. We just want to sell it and cash in and go invest in other stuff. So I said, okay, let me look at the trust. So I pulled open the trust. This was not a client of ours. Their parents had gone to another attorney to get this set up. And I said, well, we've got a problem. He said, what's the problem? I said, the problem is, when your mom passed away, they had a provision in their trust that triggered, not at that time, but it triggered a potential capital gains tax. And it didn't get paid at that point because your dad didn't sell the home. It's been sitting there for all these years. And now that you guys are going to sell it, there's going to be a massive tax. And they said, well, what do you mean by massive? And I said, roughly $100,000. And you can imagine their jaws just dropped. Now, the really sad part about this was not a super wealthy family. They didn't have like a $50 million home on the beach. This was a regular home that they lived in, a modest home. It was nice, but this was a $100,000 tax.
And that was really the biggest asset in the estate. They had a trust for the house, really.
Yeah, in fact, what was crazy is they'd set up the trust, I imagine, they weren't my clients, to avoid probate. The tax, the $100,000 tax, was way more than the probate fee would have been. And had they not set up a trust, it probably would have been better off tax-wise. They still would have gone through probate, but again, it would have been cheaper. So,
and by the way, we're not saying don't set up a trust and go through probate.
Right, no.
But comparatively, financially, they would have been better off.
It's just ironic.
It's just ironic, yeah. And so here's the bottom line. When you set up a trust, there's a common misconception that as long as you have a trust, there are no taxes. That is not true.
If only.
There are a lot of taxes.
You know, this is a good point because a lot of people think probate is a tax. And if you avoid probate, you've avoided the tax. Not true.
Yeah.
It is not a tax.
Probate is an attorney fee and a court cost. It's not a tax. So here's the bottom line. There is a way to set this up, but here's the problem in fairness to this attorney who had set this up for the parents, this trust. When this trust was created, it was many, many years ago, probably 20 years ago. At that point, the attorney obviously did not know when mom and dad were going to die. There was no way he could have known. But in order to solve this tax trap, he would have had to know when they were going to die and what the laws were going to be and the size of the estate and on and on and on. Nobody knows that. The IRS, this is the interesting part, they approved a provision called a capital gains election. This was like over 30 years ago. This is not new. This has been around for decades. But they approved this thing called a capital gains election that allows you flexibility where you don't decide when you set up your trust how the taxes are going to work. You just don't make a decision because you don't know. Congress could change the law next year. Your estate value could go up, it could go down. Parents could pass away decades apart or a year apart. There's so many variables that it's almost impossible to predict. And so what the capital gains election says is we don't know, but we do know down the road we will know eventually. So we're going to defer the decision until we know. It's like gambling after the game is over. You say, well, who won the game? Seems like a safe bet. And again, that sounds illegal. It is for gambling, obviously, but the IRS approved this 30 plus years ago. And so a capital gains election, although very simple in the end, is very powerful. And it would have saved this family over $100,000.
So here's the question. Everybody's asking this question. Why isn't this included in every single estate plan? It is a no-brainer. Why isn't it in there? I'm hearing you, and I know what you're talking about. I find it hard to believe.
I know. I think part of the problem is attorneys don't know it exists because it's so old. It came from a court case 30 plus years ago. And so I think they just don't know. And the other thing is there's kind of a standard in the industry where attorneys just like to use the same templates over and over again. You know, it's kind of like steering the Titanic. It's hard to do. Getting attorneys to change their templates is really difficult because we've had this conversation with attorneys where I'll say, did you know about a capital gains election? No, I didn't know about it. Well, let me tell you about it. And they go, well, I got to redo all my templates. That's a big project.
Well, and we're talking about a provision, but it's not one sentence. It's not a one provision. This spans the course of a few articles in the trust. It looks very complicated to read. I'm sorry about that, but that's what the IRS requires. And the principle is very, very simple. Here's the thing. There's no liability for attorneys if they don't include this capital gains tax election provision. There's no liability if they don't. But if they include something and they get it wrong because it is complicated and you've got to know what you're doing, now they do have liability. So gosh, if I don't know what I'm doing, I'm just going to leave it out.
Keep doing what I've always done.
Exactly.
Yeah,
well, and the other thing, you mentioned that this is several articles in the trust agreement. You also have to put a provision in the will, too. So it is very complicated. Now, I don't mean this in disrespect, but I have sat down with clients and I've explained this problem to them, and they'll say, well, I'll go look in my trust and see if I can find that language. And you're laughing, and I agree with you, because if you find the language, you have no idea what you're doing, because it is complicated language that is not recognizable. The language doesn't say, we don't know what our estate's going to be worth when we die, therefore we'll postpone it as long as it doesn't say that. It's very complicated internal revenue language that, you know, you can spot it if you know what you're doing, but if you don't recognize it, and most people don't, most laymen don't, you can't find it. But it's very, very uncommon.
So the key is a capital gains election. So if you're keeping track of these problems and these solutions, that's the fourth one. And write that one down because it's obviously an important one.
So let's talk about changes. That it isn't a question of whether there might be or could be or possibly changes will occur. Changes will occur, and there needs to be a process, a system, a method of addressing these changes, a communication from the attorney who drafted the document to the client. Most of the people that we talk to that come to us from other attorneys don't have any kind of a system. They haven't heard from the attorney for years, and it's very frustrating. They don't know whether the documents are current, they don't know whether they're outdated, they haven't heard anything. So it's extremely frustrating. So what we've developed is a series of things that we think address this system of keeping the documents current. For example, monthly newsletter, a very effective way of keeping track of our clients, keeping track of communicating information to them. And these aren't long treatises, they're very simple, right to the point newsletters, which I might say we write our own. We don't hire some firm from New York to write these articles for us. We actually take turns among us writing these articles.
Well, because we talk to our clients all the time, and so we know what issues are pressing, what issues we need to address, what the confusion may be, what people are asking about in changes in the law. So I think it's wonderful that we are the ones, although, and we're the ones who have to do the work. But it's worth it, because I know what my clients need to know. I know what's plaguing them.
And that leads to another process which tells us what's plaguing them, if we want to use that word. Every month, last Friday of every month, 1 o'clock, we have a live webinar with any of our clients who want to join in. And it is not unusual to have 500 people sign up for a particular topic. It's called the Q&A session. So we'll introduce a topic, and then they can ask questions about that, and then they can go off and talk about other things if they want to. But Jennifer's right. We take this information, find out what is concerning our clients and what there's some miscommunication about out there, and then we'll incorporate that into a newsletter. We also will take that information and do an annual presentation where we're not just taking questions on the fly, we're actually putting together an hour program where all the attorneys are giving a presentation. In addition to that, we send you a letter annually, and the letter basically says these are the decisions you made last time you looked at your estate plan. Has anything changed? Has the guardian for your child, are they still the best option? Is the trustee for your trust still able and functional and able to follow this? Have there been any births or deaths or marriages in the family? What has changed in your family? Plus, have your assets changed? Have you remortgaged your property? Have you bought another piece of property? Have you sold something? Constant personal changes. Then in January, we send out a letter that basically says, here's what's changed in the law. And some of those changes are, by the way, this is important to know. And some of them are, by the way, this is important to know because we need to make a change in your document. May we have your permission to do that? Now, this is a structured, proactive system where we are communicating with you and allowing you to communicate back with us. Could you just pick up the phone and call us and ask a question? Of course. Could you make a revision to your documents that's personal, not required by law, not suggested by us, but something that you want to do? Sure, we can do that. And the question is, how does this whole process work? And the answer in a phrase is proactive. It's a proactive system where we are constantly reaching out to you and making sure that you are aware of and that your documents are current and up to date and you are familiar with the terms of the document. Sometimes we meet with clients from other attorneys who haven't reviewed and looked at their documents in years, and they're shocked to find out what they say. Very surprising that they haven't read them for years, and even when they did read them, they didn't understand the particular provisions in them that were outdated. So this is a system that basically says, let's keep the documents current. And by the way, this is completely separate than creating the documents. Once we create the documents, then we go to the next step of keeping the documents up to date.
So let's recap the 5 major problems that we've gone over today. The first one is the problem of probate. The second one is keeping assets in the family, which is huge because you could avoid probate and still have assets going to entirely the wrong person. Major problem that needs to be addressed. The third one is incapacity. How does your trust deal with you developing dementia, Alzheimer's, or having a stroke? The fourth one is the capital gains tax trap, which really is even scarier than it sounds because this could result in the loss of thousands or even hundreds of thousands of dollars. And the fifth problem is the inevitable changes that are going to happen in your life and in the law. So we've actually developed a set of documents that addresses and solves all of these problems. The industry standard does not. The industry standard is to solve the one major problem that people know about, and that's probate, but all of these other problems are way more costly and create a much bigger disaster. So the solution that solves all of these is called the life plan. Now, before you go and ask some other attorney for the life plan, just know that it is copyrighted and trademarked. So in fairness to other attorneys, they're not going to know what this is. And again, most attorneys are following the industry standard that doesn't have any of these solutions. And another concern or question, I guess, that is fair to ask is, okay, if you've developed this life plan, how do we know that it's safe to use? Fair enough, but this has been developed and tested over the past 25 or so years with thousands of clients all over the state of California. Yes, these provisions are upheld in court, and so now they don't go to court anymore. There's a case law that has upheld every single one of these provisions. Yes, the IRS recognizes the tax flexibility language that solves the capital gains tax problem. Yes, these provisions are effective and they work, and they've been tried all across the state, and it's really something that gives so many people such peace of mind to know that virtually anything could go wrong, and their documents in the life plan are designed to address all of it, to keep things very simple.
And by the way, I want to emphasize something that Jennifer has said, and that is the features. The features are what make the difference.
Yes.
So, do I have a trust? Yes. Do we suggest a trust? Yes. Are they the same? No.
No, right?
There's features here that don't exist here, and you can read both of these documents all day long and spend a horrible weekend going through these legal documents. I wouldn't wish that on my worst enemy.
Right.
And at the end of the day, you don't know whether the features are there. So if you think about what we've been sharing with you, focus on the features. We mention the features and then we comment that this is in the trust, or this is in the will, or this is in the power of attorney. Do not conclude that if you have a list of the documents that we referenced that you've got it done, and that's all you need is these list of documents. The features have to be in the documents to accomplish the objectives that we're talking about.
That's such a great point. The documents, it's not different documents that compose the life plan. It's the features in the documents, the words, the language, and how do the documents work? How are they applicable? That is the difference between the industry standard and the life plan. But I'm sure that you want to know, hey, the life plan sounds great. What does it cost? So let's talk about that next.
So as you can see on the screen, we have two fees for the life plan. The only difference is whether you're married or single. Married fee is $48.50. Single person fee is $38.50. Now, one of the common questions we get is, does that fee include all the features and all the things that we've just discussed in this webinar? And the answer is yes, it does. So you don't have to worry about something being missing from there or not included because you forgot to ask. We've developed the life plan to solve these problems, and we know how to solve them. That's why we include all those features and all those provisions. And that's candidly why we just spent the time today to share these with you, because most people aren't aware of them, and we know they need to be there. Now I'm going to mention this too very quickly just because people have a question. They will often say, well, is a life plan a trust? Does a life plan have a power of attorney? Does a life plan have a will? Yes, those are the core documents that every estate plan should include. But here's the key. The documents themselves don't make much of a difference. What's inside the documents is what matters. In other words, it has to say inside the trust, I want to keep this in the family. We don't say it that way, but right there has to be a provision that says that. And so you could have two trusts that are both trusts, and one doesn't keep it in the family and one does. So the life plan is what we put inside the documents. It's not necessarily the document itself, but all those are included.
So if you're comparing, be careful. Don't compare a trust and a will and a power of attorney with a trust and a will and a power of attorney that was developed under the life plan. They both look the same. The layman can't tell the difference.
Now, the next part of this is, let's say you set up a life plan and everything's in good order and you're happy and it's solved all these problems. There's still this issue that we talked about earlier, that is, things are going to change. I can't help you stop that from happening, right? I can't fix that problem. It is going to happen. Things are going to change. The question is not, will things change? The question is, do we have a system in place to address it so that it doesn't cause a problem? We have an optional life plan membership that we give free to our clients for the first year. So if somebody sets up a life plan today, they have a whole year free to try this life plan membership. That includes all the stuff John was talking about earlier. The annual review, the monthly webinar, the newsletter. Making changes to your documents is included. If you want to update stuff and make an amendment, do something different, that's included. If you want to have a phone call. All of these things are part of the life plan membership. But because most people we talk to say, oh, I've never tried something like that, I don't know what it's like, we give you a year. Try it for a year and see if you like it. At the end of the year, it's an optional thing to continue if you want. The fee per married couple is $395 per year. It's not per hour, that's per year. And then $295 if you're single. And so the purpose of all of that is to basically say, there's a problem, we know it's going to happen eventually, we've discovered a cost-effective way of dealing with it. But we don't require it. People can choose if they want to do it, but at the end of the year, you'll know if it's something that's beneficial to you or not. Now, one other question that we often get is, what if I already have a trust? What if I've already taken the time to set up a trust? I know it's out of date, I know it does not a life plan, I know it doesn't have all these features, I need a life plan. How does that work? Well, the only difference between setting up a life plan for someone who doesn't have a trust currently and someone who does is when you have a trust, we want to keep the name and date the same. Because that name and date is going to be on your deed, it's going to be on your bank account. That's the whole funding process you went through, and I'm sure many of you are thinking, I don't want to do that again. That was a lot of work. The good news is you don't have to. We do a restatement of your trust, which means it's still in the trust, the title's still the same, but we've improved the document. So this new document kind of supersedes almost the old one. It says this version now has superseded the old version. And so the fee is the same. If you want to set up a life plan, whether you have a trust or you don't, it's still $48.50 for married couple, $50 for a single person. So the question now that everybody asks is they go, well, how do I know that this really works? Where's the social proof? Have you guys really done this? Have you helped thousands of clients? And so we want to show you something on the screen right now about our Google reviews.
As you can see, we have hundreds and hundreds and hundreds of 5-star reviews. The thing I love about these Google reviews is when I started practicing law, people would ask for references. Well, some of you may know this, but there's this little thing called attorney-client privilege. I can't tell you who my client was, and I can't give you their name and phone number and have them call or you call them. I couldn't do this. When Googles arrived, I'll call them Googles, it was really cool because people would tell you how they felt.
Now that you've learned the 5 common estate planning problems and how the life plan solves all 5, the next step is simple. We invite you to schedule a free phone appointment with one of us to discuss your situation and see if we might be able to help. Now, this phone appointment has just a few requirements. Number 1, you need to be a California resident. We're only licensed in California, so if you happened upon this webinar and you're not a resident, we wish you well, but we're not allowed to help you. That also brings up a second part, which is very important, and that is we cover the entire state of California. We always have for 40 years. Our office is in San Diego, but most of our clients do not live in San Diego. And so this is not something that we just started last week, and we're hoping it'll work. We've literally been helping thousands and thousands of clients all over the state for 40 years.
You know, the funny thing about that is they could start and end this whole process and never leave their house.
That is true.
Literally.
That is true. We use email, we use Zoom, we use phone, we communicate with our clients through various methods, and they can do it all from home. They can have a mobile notary come to their home. They can get their
Which
box.
we provide.
Yeah, which we provide. They have a FedEx box that brings their trust to their doorstep. So the point is, if you don't live in San Diego, which again most of our clients don't, that's not an issue. Thousands and thousands of clients before you have done the exact same thing, and they've loved it. They actually like it better because they don't have to drive
that
anywhere.
all the time.
Yeah, they don't even have to put their pants on. You can stay home and get this done in your pajamas.
Whoa.
It's great. So that's the first requirement, California resident. Number 2, this needs to be your estate plan. Do not schedule an appointment if you have questions about your parents or your friends or your siblings. It's not that we can't help them, it's just we can't address their stuff through you. That's not
Have
how it
them
works.
call. We're happy to talk to them, but have them set up the appointment, not through you.
Yep, absolutely. And then the third and final one is both spouses need to attend the appointment. So if you're married and you have joint property and a joint trust, because it's community property, we need to be speaking with both spouses. So when you pick a time, make sure you find a time that works for both of you. Now you'll see a link that's going to pop up here on the screen. That's a link to our calendar. Click that link, it'll show available dates and times in the next couple of weeks. Pick a date and time that you can make it. The appointment is on the phone, so you'll enter your phone number. We will call you at that time. You don't need to prepare for it. You don't need to send us anything. You don't even really need to be thinking about it. Just make sure you're available at that time. We will call you and we'll take it from there. Any other thoughts or final?
Thank you for spending the hour with us. It was
Yes.
good to see you.
That's a commitment that you've already taken, so good for you.
All right, we'll talk to you soon. Click the button now. When this ends, the screen will pop up and you can schedule it then too. Thanks for taking the time. We'll talk to you soon.
Okay.